All right, everyone, let us continue our discussion. In my previous session, I had discussed the essential elements of a valid contract. Let us continue, and in this session, we will discuss classification of contract. Okay, so let's get started. Before I discuss the provisions, what kind of questions can be asked? So if you're preparing for an exam having theory or theory and case-based questions, so yes, theory question can be asked on any one of these contracts. So they may ask you to define define an unenforceable contract or a void contract, or they may ask a difference between question from this. A case-based question can also be asked on void contract, illegal contract. So a variety of questions can be asked from this. Even if no question is asked, I think this concept is this classification is very important, because unless and until you don't understand the type of contract, you will not be able to understand the entire contract. Okay, so at many places you will find the words like void contract or an illegal contract, or an executed contract, executed consideration. These words are used, so you need to know the meaning of the terms in order to understand the act better. So let us see how contracts are classified. Now, contracts may be classified according to validity as void contract, voidable contract, illegal agreement. According to enforceability, they may be valid contract or unenforceable contract. According to formation, they may be classified as express contract, implied contract, or tacit contract. And according to performance, they may be executed or executory contract. So this way, I have classified all the contracts in a proper tabular format, so that it is easy for you to understand and remember. Now, according to validity, contracts may be either void contract, voidable contract, or illegal agreement. Let us discuss them one by one. Now, what is the meaning of a void contract? This is something which we studied in the earlier lecture. Yes, we discussed that void may be either void ab initio or just void. Void ab initio means it is void right from the beginning. Can I say if it is void right from the beginning, I will not call it a contract, I will call it as a void agreement. So over here, we have also defined void agreement. Void agreement, it means it is void right from the beginning. It's just an agreement. It doesn't become a contract because there is no enforceability. So over here, you can conveniently write this is nothing but void ab initio. It is void right from the beginning. It is unenforceable by law right from the beginning. Can you recall the examples that we had discussed? Yes, examples will include killing. Yes, you are entering into contract to kill a person, smuggling, gambling. These are void right from the beginning. Contract with minor, yes, very good. Contract with minor. So all these are void right from the beginning. There is no enforceability, hence it is just an agreement. A void agreement does not give rise to any legal consequence. It is unenforceable right from the beginning. So unenforceable right from the beginning, it means it is void ab initio. It does not give rise to any legal consequences. It means there is no enforceability. Okay, there is no enforceability. Void agreement never matures into a contract. There is no enforceability. It's just an agreement. It will never become a contract. Then what is the meaning of void contract? Do you remember the example we had discussed? A promises to marry B. It's a valid contract. It's a valid promise. But before marriage, A dies. Now, because of this circumstance, the contract cannot be enforced. It becomes void. Keep this example in mind, and then let us read the definition of a void contract as given in Section 2, Clause J. Section 2, Clause J of the Indian Contract Act defines void as a contract. It means it was valid when entered. It's a contract. which ceases to be enforceable by law. Okay, so it was a contract, but now it ceases. The meaning of the word cease is stops. Okay, so a contract which ceases to be enforceable by law, what does it become? It becomes void. When does it become void? When it ceases to be enforceable. So this is actually talking about the time when the contract becomes void. Let us read it once again. Okay, a contract, it means it was valid, which ceases to be enforceable by law. So a contract which ceases to be enforceable by law becomes void. When does it become void? When it ceases to be enforceable. So this is the point of time when the contract becomes void. Okay, so let's read it once again. A contract which ceases to be enforceable by law becomes void. Does it become void? When it ceases to be enforceable. So can I say void contracts are those contracts which are valid when entered, but later on, due to certain circumstances, they become void. Once they are void, it means they are not enforceable by law. So can I say void is opposite of valid? And we discussed all this in the previous session when we were studying the essential elements of a valid contract. Yes or no? Okay, so void means it is not enforceable by law. It has no legal effect. It is the opposite of valid. Contract is valid when it was entered, but later on, due to certain circumstances, it becomes void. Definition is given under section 2, clause J. A contract means it was valid when entered, which now ceases to be enforceable by law, becomes void. So a contract which now ceases to be enforceable by law becomes void. When does it become void? When it ceases to be enforceable. So by going through the provisions again and again, you will be able to learn them and easily recall them one day before the exam. Now let us discuss the meaning of voidable contract, and for that I will request you to prepare the chart, maybe along with me or after you finish understanding the concept. It is better that you wait. Let me explain it to you and then you can write it. I will give you time to copy. Now, what is the meaning of a voidable contract? Voidable means it is an avoidable contract. Okay, it is avoidable. All right. Now, let us first understand the example, and from that we will develop the concept. Now, a Don wanted the house of X. So he threatens X. Sell me your house or I will kill you. X is not disturbed by it. He's not affected. He said, oh, I am not affected by your threats. Then Don called his friends. I hope you understood. They started beating X. X got scared and he agreed to sell his house for rupees 5 lakhs. The house was actually worth rupees 5 crores, but he agreed to sell it only for 5 lakhs. Okay. So let me write it over here. The Don paid 5 lakhs to X and in return, X gave his house. But was X's consent free consent? X's consent is obtained by coercion. Okay, X's consent is obtained by coercion. Who is the dukhi party? Okay, the sad party, the party who did not give their free consent. Yes, it is X. X, the dukhi party, the sad party, has two options. Keep quiet, treat the contract as valid. So X, the dukhi party, also known as the aggrieved party. Okay, the dukhi party, the aggrieved party has two options. Keep quiet, treat the contract as valid. So X may feel that, "Arey yaar, let it be, ghar gaya to gaya, jaan to bachi. Even though I have lost the house, at least my life is saved." So he decides to keep quiet and treat the contract as valid. Or he can go to the court and he can prove that coercion was used. He can use this inadequate consideration. See, the house was worth 5 crore rupees, but he's selling only for 5 lakh rupees and he was forced to do so. he can use this inadequate consideration as a piece of evidence to show that the consent was not free consent. So he will go to the court, he will get the contract cancelled. Okay, he can get the contract cancelled. Now, if the contract is cancelled, he will get back his house. But what about this 5 lakh rupees which he has received? Can he keep the house as well as that money? No, 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 no. He cannot both keep the house as well as the money. Once the contract is cancelled, the benefit will be restored. So he will have to restore the benefit. We had studied this provision earlier also, but that was covered under section 65 because it related to void contract. This relates to a voidable contract and it is therefore covered under section 64. Both the sections are different, although they talk about restoration of benefit, but there it was restoration of benefit for a void contract or a contract which is subsequently declared void. And here restoration of benefit in case of voidable contracts is covered under section 64. Once the contract is cancelled, you can say that the contract becomes void. Another word for cancellation, you can also say he can rescind the contract. Rescind means to cancel. Another word for cancel or rescind is repudiate. Okay, so these are better words for cancellation. So if in the exam you write these words, it will add value to your answer. And if rescind or repudiate word is used, you should understand that they are talking about cancellation. Okay, so let us recap and revise the concept. What is a voidable contract? Voidable means it is avoidable. You may later on go to the court, prove that your consent was not free consent. You can avoid, you can cancel the contract and you can claim back the goods or house or whatever property that you have parted with. The benefit which you have received will have to be restored. So this option is available with the aggrieved party, and contracts where such option is available with the aggrieved party are known as voidable contracts. These options are available only and only with the aggrieved party. They are not available with the other party. Contracts where the consent is obtained by, okay, contracts where consent is obtained by coercion, undue influence, fraud, and misrepresentation. They are voidable. Ma'am, you forgot mistake. Contracts where consent is obtained by mistake, okay, especially bilateral mistake, they are void. Why so? Now I will explain, but first understand that where the contracts where the consent is obtained by coercion, undue influence, fraud, misrepresentation, they are voidable. But where the consent is obtained by mistake, the contract is void. Now, voidable contracts are such contracts where the aggrieved party has two options: keep quiet, treat the contract as valid, or cancel the contract. Now, these options are available only when the consent is obtained by coercion, undue influence, fraud, and misrepresentation. You will not select voidable option because you feel like. You will go for voidable only when it is specifically mentioned in the act. So when the act says that the contract is voidable, only then you will consider the contract as voidable. Otherwise, you will go with either valid or void. So voidable contracts are those contracts which are specifically mentioned as voidable in the act. If the act is specific that this contract is voidable, only then you will select the option voidable. Now let's say in Sale of Goods Act, if there is an auction sale, okay, and you make use of pretended bidding, then law says it is voidable. Only then you will consider the contract as voidable. When time is essence of contract and it is not performed on time, that time it is mentioned in the act that the contract is voidable. Only then you will consider as voidable. Otherwise, you will always go with either valid or void. So don't select voidable option just because you feel it is the correct option. Okay, go for voidable only when it is specified in the act. Now, do you really think that we are going to remember all this for exam? We will not remember. It is not possible for us to remember the entire act wherever it is, wherever the word voidable is mentioned. So what you can do is, on the last page of your notebook, you can prepare a list of voidable contracts. So whenever voidable, you come across voidable in the theory, immediately go and make a note in that list, keep on adding. So by the time you are ready with your contract act, you will come to know the contracts which are voidable. So you have a list of all the voidable contracts, and only in those contracts you will go for voidable. Otherwise you will always stick with options like valid or void. So up till now we have studied that contracts where the consent is obtained by coercion, undue influence, fraud and misrepresentation, they are voidable. Now, why is consent obtained by mistake void and not voidable? Let us go through the examples which we had studied earlier. X and Y, they enter into contract for sale of horse, but unknown to both the parties, the horse had already died in the stable. They were not aware of it. Now, if like other contracts, they insist that no, for us also the contract should be voidable, it means the aggrieved party will have two options: either treat the contract as valid or cancel the contract. Is it really possible for us to treat the contract as valid? How will you buy a dead horse and how will he sell a dead horse? It is not possible at all. The only option available with us is to cancel the contract, and once you cancel the contract is treated as void. It is not enforceable by law. So that is why the contracts where consent is obtained by mistake is void. Let us discuss one more example to validate this. X is the owner of 3 horses, but Y thinks that X owns only 2 horses. Y says to X, I want to buy all your horses. Okay, I wish to buy all your horses. Now, at the time of delivery, X will deliver 3 horses, but Y says, no, I want only 2. Are they agreeing upon the same quantity in the same sense? There is mistake of quantity. The contract is not valid. So X and Y, they are not agreeing upon the same quantity in the same sense. So here there is mistake of quantity. They are not agreeing upon the same quantity in the same sense. It makes no sense in entering into the contract. The only option available with us is to treat the contract as void. Can we treat it as valid? How will you treat it as valid when X is saying, I want to sell 3 horses, and Y says, no, I need only 2. They are not agreeing upon the same quantity in the same sense. Y thought on his own. See, that is the main difference between misrepresentation, fraud and mistake. In misrepresentation and fraud, you are saying something, but in case of mistake, both are understanding something on their own. So here, Y on his own thinks that X owns only 2 horses. So even if they want, they cannot treat this as a valid contract. The only option available with us is to treat it as void. That is why consent when obtained by mistake is a void contract and not voidable contract. There are a few other points which I want you to make a note of. So let me write those extra points over here. Okay, let me write these extra points now. Contract remains valid till rescinded. It means that the contract will remain valid till the aggrieved party decides to cancel the contract. That is why it is known as a voidable contract and not voidable agreement, because it remains valid till the aggrieved party decides to cancel the contract. So, ma'am, can the aggrieved party decide anytime, like, after 2, 3, 6 months, 10 months? No. Whatever decision you want to take, the rescission, okay, the decision to rescission must be within a reasonable time. Okay, this decision must be taken within a reasonable time. Now, what is reasonable? That is not defined in law. It depends upon the facts and circumstances of the case. What is reasonable? We don't know. It depends on the facts and circumstances. Okay, now the options are available. Okay, options are available only and only with the aggrieved party. Okay, only with the aggrieved party, and not with the other party who is using coercion, who is using undue influence, or who is committing fraud. Okay, options are available only and only with the aggrieved party. I'll just push this on top so that it is clear. Let me push this little below. Okay, now we have a lot of space. So contract remains valid till it is rescinded. Till you take the decision to cancel, it will remain valid, and the options are available only and only with the aggrieved party. They are not available with the party committing coercion. Once the contract is cancelled, okay, once the contract is rescinded, benefit shall be restored. Okay, once the contract is cancelled, the benefit will be restored. So this is covered under section 64, restitution of benefit in case of a voidable contract. Void contract was discussed under section 65. So contract remains valid till it is rescinded. Options are available only and only with the aggrieved party, and the contract, whenever cancelled, benefit will have to be restored. So these are few extra points, and now I think it is time for you to pause the video and copy all this in your notebook. Done? Okay. What about this? Let us write this also. All right. Now, let me read all this. We have actually covered every point in that chart. Section 2 clause I defines voidable contract, an agreement which is enforceable by law, but at the option of one party, not at the option of the other, then that contract is known as a voidable contract. It is enforceable at the option of one party. One party is the aggrieved party. Now this option is available only and only with the aggrieved party and not the other party. Then such type of contracts are known as voidable contracts. Contracts where the consent is obtained by coercion, undue influence, fraud, and misrepresentation, they are voidable. But contracts where the consent is obtained by mistake and bilateral mistake, that is of both the parties, then the contract is void. Until the contract is avoided or rescinded, rescinded means cancelled, then it is considered as a valid contract. So contract remains valid till it is cancelled. And the cancellation must be within a reasonable time. You cannot exercise that option whenever you want. It must be within a reasonable time. Illegal agreement. Yes, now let us discuss illegal agreement. The word they have used is agreement. They have not used the word contract because this is void right from the beginning. It is void ab initio. So what is an illegal agreement? Now please note, students, that the word forbid will give you a hint that they are talking about illegal agreement. So illegal agreement is one which is forbidden by law, like gambling, entering into contract for killing. Ma'am, this is void ab initio. Yes, same examples. So gambling is illegal in India, smuggling is illegal in India, threatening at gunpoint, yes, you can see it. It also amounts to coercion actually, but it is punishable. So illegal is one which is forbidden by law. It is contrary to law. It is against law. It is something which the law forbids to be made. These agreements are void ab initio. Now, let's say for example, that X and Y, they enter into gambling contract. Now in India, gambling is illegal. X lost. He didn't have money to pay Y. So he borrowed 10 lakh rupees from Z. Now because the main agreement is illegal, the collateral is also tainted with illegality. Uspe bhi illegality ka daag lag jata hai. Okay, this is also tainted with illegality. And the agreement is void. So let us also prepare a small table. Okay, now if the main agreement, all right, if the main agreement is illegal, the collateral, what is the meaning of collateral agreement? Collateral means additional agreement. The meaning of the word collateral is additional. If the main agreement is illegal, the collateral is also tainted with illegality. उस पे भी illegality का दाग लग जाता है. And hence the agreement is void. But ma'am, what if Z was not aware of the purpose of the loan? What if X had lied to him? Then the contract will be valid, but you have to prove it. Okay. So here it will be valid only when party is able to prove its innocence. Okay. Just if you have any doubt that will it be valid? Yes, only when the party is able to prove it's innocent. Now also let us discuss what if it is a void contract. What about void contract? What is the situation in a void contract? X promises to marry Y. X proposes to Y, Y agrees. Now because there is marriage, a lot of money is required. So X takes loan from Z for his marriage. But before marriage, X died. Or let's say Y died. So it's easy for us to understand the contract between X and Z. Okay. Now, let's say Y died. So this contract becomes void because now marriage is not possible. What about the loan? Can we tell Z that, listen, marriage did not take place, so now I will not repay the loan? That's not the case. No, you have to repay the loan. The collateral will remain valid. But law does not expressly call it valid. Law says if the main agreement is void, the collateral need not be void. They are so smart. They are saying it need not be void. It means sometimes it can be valid, sometimes it can be void. So it depends on the situation. So they are so smart. They are saying that collateral need not be void. It means sometimes it can be valid, sometimes it can be void also. So here, even though the main agreement of marriage did not take place, but X will have to repay the loan to Z because this agreement of loan is valid. So if the main agreement is void, collateral is not affected. The collateral need not be void. So it may remain valid, it may become void. We are not concerned. Okay, but it need not be void. So it can remain valid also. Okay. Now, this is the effect on collateral. I think you can now pause the video and copy all this in your notebook. This table will definitely help you in your examination. If the main agreement is void, the collateral need not be void. But if the main is illegal, the collateral is also affected by illegality. The collateral becomes void. So that was about illegal. Now, according to enforceability, contracts may be either a valid contract or an unenforceable contract. Valid contract is a contract which satisfies all the conditions prescribed by law. All the essential elements are present. So valid contract is a contract wherein all the essential elements are present. It is enforceable by law. Then what is an unenforceable contract? See, unenforceable contract means it has all the elements except legal formalities. So like this, it is a valid contract, but it should be in writing and these parties did not get it in writing. So for the time being, it is unenforceable. I got it in writing, then the contract becomes enforceable. So basically, it is valid. It is actually valid, but it can't be enforced because of some technical defect, because of some legal formality that was not complied with. So the contract was to be in writing, registered. I had to get it attested. I did not. So for the time being, the contract is unenforceable. I got it in writing. I got it registered. I got it attested. Then the contract becomes enforceable. So these contracts, they can be enforced once the technical defect is removed. Now tell me, will this be a valid and enforceable contract? X agreed to sell his flat to Y and they made an oral agreement. Is this valid? No. If it is an immovable property, we have studied. In case of an immovable property, the contract must be in writing. It must be registered. Yes, it must be in writing and it must be registered also. So for the time being, it is unenforceable. I got it in writing. I got it registered also. That becomes enforceable. X agreed to gift his car to Y. They prepared a gift deed, but they did not get it registered. Not done. Gift deed must be in writing and it must be registered also. It must be in writing and it must be registered also. So for the time being, it is unenforceable. You get it in writing, you get it registered, it will become enforceable. According to formation, we have contracts classified as express contract, implied contract, or tacit contract. Now, express, the word express means it is expressed in words, oral or written. Okay. So, expressed means words are used, either oral or written. So, X writes a letter to Y offering to sell his car. Y also replies by letter. Words are used. It's an express contract. X calls up Y. Okay, he calls. This is telephone. He calls and says, I want to sell my flat to you. Y also replies on that same call. Okay, I will buy that flat. When both the offer as well as acceptance, both offer as well as acceptance, they are made in words spoken or written. Okay, so when both offer as well as acceptance, they are made in words spoken or written, then they are known as express contract. So express contract is a contract wherein both offer and acceptance, they are made in words. But words are not used. It is understood from our action, fact, circumstances of the case. Then it is an implied contract. I want you to write a small chart for this. Okay, give the heading as implied contract. Now, contract may be implied either by fact or it may be implied by law. In case of contracts which are implied by law, these are also known as quasi-contracts. Quasi means they are just like a contract. Now, implied by fact means words are not used. Words are not used. The contract is inferred. Inferred means it is understood. From facts, or we can say action, facts, and circumstances of the case. Okay. So implied means words are not used, but it is understood. It is inferred from the action, facts, circumstances of the case. So let's say for example, that X boarded a bus. Okay. Now, the bus is running on a fixed route. It's an implied offer that I am going to the station. If you want, you can board the bus. So bus is running on a fixed route. That's an implied offer. X boards the bus. That's an implied acceptance. I am using your services. I will pay for it. Words are not used. It is understood from our action. Another word from action, you can also use conduct. Okay, so words are not used, it is understood from our action. Another example will be of auction. Another word is auction. Okay, now in case of auction, have you ever witnessed an auction sale? There are groups sitting, they will just raise the card, it's an offer, I want to bid. Auctioneer will strike the hammer, it means it is sold. Words are not used, it is understood from our action of raising the card that I want to bid, and he will simply strike the hammer, it means his action shows that our offer has been accepted. In case of a buffet restaurant, the buffet is displayed. We take a plate, that's an implied offer. The restaurant owner allows us to do that, that is implied acceptance. Words are not used, it is understood from our action. Sometimes the contract may be implied by law. Parties never intended to enter into contract, but law says the situation is such that it is a contract. Now let's say that A, by mistake, left goods at the house of B instead of C. B used the goods. Now if you have used the goods, you will have to pay for the goods. In this case, there was no offer. There was actually no acceptance. But we cannot allow B to enjoy at the expense of A. If you have used the goods, you will have to pay for the goods. This is nothing but a contract which is implied by law. So in this case, parties never intended to contract, but the contract is imposed by law. Okay? Parties never intended to contract. Law says that there is a contract between you two. Another example is finder of goods. Now, X found a diamond ring and he didn't know who it belonged to. So you have to keep the ring with yourself, take care of it, try to find the true owner. Once the true owner is found, it is your obligation to return the ring to the true owner. If the true owner is not paying your lawful charges, you can keep the ring till your charges are paid. So we will study that later. But finder of goods, there is no offer, there is no acceptance. There was no contract that he will take care of the goods, but because he has found the goods belonging to some other person, he assumes the role of a caretaker. He has certain rights, certain duties which are imposed by law. So this is also an implied contract. It's an implied contract that you have to take care of the goods till the true owner is found. And once the true owner is found, you have to return the goods to the true owner. So this is an implied contract. So students, this was implied contract. Just note it down, and then we will also study what is the meaning of tacit contract. Then let us understand the meaning of tacit contract. See, the word tacit, it means understood from silence. Tacit contract is not a separate kind of contract. Okay, it is not a separate kind of contract. It is a part of contract implied by law, implied by fact. Okay, so this is not a separate kind of contract. It is a part of contract which is implied from the fact, circumstances of the case. So you will not find a separate classification of tacit contract anywhere. This is understood from silence. Now, only and only under these two examples you will consider the option as tacit. Okay, otherwise you will select implied by fact or implied by law. Withdrawing cash from ATM. Have you ever withdrawn cash from ATM? Do you go and talk to the ATM machine? How much cash will you give? Whether you will give me 100 rupee note or 500 rupee note? We don't talk, no? We just insert the card. If there is money in our account, we will get the payment. So withdrawing cash from ATM is a tacit contract. Okay, so withdrawing cash from ATM, that's a tacit contract. Sale by fall of hammer. Over here also I mentioned auction because tacit is a kind of implied by fact. So you can write over here tacit contract. Okay, because tacit is not a separate kind of contract, it is implied by fact only. So sale by fall of hammer in case of an auction sale. So only and only when withdrawing cash from ATM, sale by fall of hammer, that is auction sale, only and only under these two circumstances you will select tacit contract. Otherwise you will go with implied by fact or implied by law. So this is not a separate kind of contract. It is a part of implied by fact. Done writing? So implied means it is made otherwise than by words, either spoken or written. It is inferred, it is understood from the conduct of the parties, circumstances of the case. These are implied by fact. Now what are implied by law? Implied by law means that parties never intended to contract, but law says because of the circumstances a contract is created. Tacit contract. Tacit means it is silence. Words are not used. It is inferred from the conduct of the parties without any words. It's not a separate kind of contract. It comes within implied by fact. Lastly, what is executed contract, also known as unilateral contract, and executory contract, also known as bilateral contract? Now, what is the meaning of uni? Uni means one. Okay, so this is a one-sided contract. Right, now let us understand both separately. Executed contract, it means everything is over, nothing remains to be done. X sold apples to Y. Y made payment also. So X gave the apples, Y made the payment. This is an executed contract. Both the parties have fulfilled their obligation. When both the parties have fulfilled their obligation, it is known as an executed contract. Nothing remains to be done. X gave money to Y. Y delivered the goods. Nothing remains to be done. Everything is over. This is an executed contract. What is unilateral? Unilateral means it is a one-sided contract. One party has performed his obligation before formation of the contract, but other party still needs to perform his obligation. Like say for example, that there was a pasta eating contest, okay? There was a pasta eating contest and the organizers, they agreed to pay a reward of, let's say in rupees, they paid 10,000 rupees to whoever ate a big bowl of pasta in 10 minutes. X finished the entire bowl in under 10 minutes. Now he is entitled to reward. So the organizers will pay him 10,000 rupees. Now, when the organizers promise to pay him 10,000 rupees, this is a contract. In this contract, X has already performed his duty. He has already performed his promise of eating the pasta. Only organizers have to pay 10,000 rupees. Now, since X has already performed his obligation before the formation of the contract, this is a unilateral contract because in this contract, only the organizers have to fulfill their obligation. X has already done his thing in the past. This is a unilateral contract because it has to be performed only by one party. It's a one-sided contract. One more example to understand this. X gave an advertisement that I will pay a reward of 10,000 rupees to whoever finds my missing dog. Y found the dog. Now Y has performed his obligation of finding. Only X's obligation remains to pay 10,000. Now, please note, students, that when X made an announcement that I will pay 10,000 to whoever finds my dog, it was just an announcement. As of now, contract was not made because nobody had actually found the dog. Only when someone finds the dog, a contract is made. Yeah, yes, you found the dog. Now I have to pay you 10,000 rupees. So till the dog is found, I don't have the contract with any person because I don't know with whom the contract is to be entered. Contract will be entered only when someone finds the dog. So Y found the dog and now a contract is entered with him. In this contract, only X has to perform his obligation of paying the 10,000 rupees. Y has already performed his act in the past. Since Y has already performed his act, only X needs to perform. This is also a unilateral contract. This is not a separate kind of contract. It's a part of executed contract because because Y has already performed his parts. It is executed from his point of view. Only X needs to perform his obligation. This is a unilateral contract. So unilateral is actually a one-sided contract in which after formation, okay, after is the keyword, in which after formation, only one party has to perform his obligation. The other party has already performed his obligation either at the time of or before the formation of contract. In my example, both these examples, the party had already performed his obligation before. But if at the time of formation, I gave the goods, but you will give me the money in the future, so then that is also one-sided contract. Unilateral is not a separate kind of contract. It's a part of executed contract. What is executory, also known as bilateral contract? In this, both the parties have to still perform their obligation. So when both the parties have to still perform their obligation, it is known as executory contract, also known as bilateral contract. X promised to supply goods to Y and Y promised to pay money. X will supply the goods, let's say on 15th of April, and Y will pay the money on 17th of April. And today is 1st of April. So he will supply the goods, Y will pay the money. Both the parties will perform their obligation in the future. This is known as executory contract because something remains to be done. Something remains to be done. When both the parties have to still perform their obligation, it's executory, and executory are also known as bilateral. Okay, they are known as bilateral contract. So with this, students, we come to an end. A note is mentioned here. As per section 64, in case of a voidable contract, party rescinding the contract, if they have received any benefit, will have to restore it. So restoration of benefit in case of voidable contract is covered under section 64, and restoration of benefit in case of a void contract is covered under section 65. So person who has received the benefit will have to restore it. So voidable contract is covered under section 64. So this is restoration of benefit. And in case of void contract, restoration is covered under section 60. So with this, we come to an end of classification of contract, and the first chapter is also over, nature of contract. All right. So after this, you will then solve the questions and I will meet you in the discussion with you.